Good evening. Before they finish filing out the door, let's just thank one more time the First Presbyterian Church of Brooklyn Choir. What a beautiful way to start this special occasion. Welcome to the 23rd Annual Derek Bell Lecture on Race in American Society. I'm Trevor Morrison. I'm the dean of this law school and very proud to be that every day, but especially today when we remember Derek and celebrate Derek through this annual lecture. This lecture is among the most important annual events at the law school, eagerly awaited by all of us. And we are delighted this evening to see members of Derek's family and friends here. We're joined by his widow, Dr. Janet Bell, and sons Douglas, Carter, and Derek Bell III. Welcome. I've remarked in past years that I didn't have the privilege of knowing Derek personally or being his colleague. He passed before I joined the faculty here, but I feel that I know him, and I feel that we work together because his influence on this institution, on legal education and higher education, on American law and society is tangible, everywhere present, and certainly in the halls of this law school. He was, as we all know, a tremendous figure in constitutional and civil rights law, in civil rights more broadly, in racial justice, and indeed justice more broadly. His leadership and the model that he sets for all of us as a scholar and a teacher and as an activist leader truly is something that we celebrate and cherish here at the law school. We are grateful that Derek, after a transformational career in so many places, whether it be the Justice Department, the NAACP Legal Defense and Education Fund, Harvard Law School, that he ultimately chose NYU Law as his final academic home, where he was broadly admired by his colleagues and by administrators and, of course, students. In 2012, he posthumously received the law school's Podell Distinguished Teaching Award, which is our highest teaching award here at the law school. And tonight, as I say, we gather to celebrate and to carry his extraordinary legacy forward, to continue to enhance and expand his work for racial reform and justice in the United States. And the mission of this lecture series is exactly that, to examine the role of race in American society and the role that law can play in achieving justice and the role sometimes that law has played in holding it back. It has served as an important platform for leading scholars and activists to share their work and insights on racial justice and civil rights. And we are thrilled that this year we are welcoming Dean Angela Onwuachi-Willig, the Dean of Boston University School of Law, to present her lecture, The Tragedies of Emmett Till and Trayvon Martin, illustrating Professor Derek Bell's lesson on how racial patterns adapt in ways that maintain white dominance. Angela will be introduced formally in just a moment by Vincent Sutherland, the executive director of our Center on Race, Inequality, and the Law. We are thrilled with the work of this center, which launched 2 academic years ago now, and is, among other things, the home of the Bell Lecture Series. And in many ways, it expands and builds upon Derek's own legacy in scholarship and activist leadership. But before we have the lecture, we're going to hear first from Dr. Janet Bell herself. She has been an integral member, really a leader of the NYU law community for many years. And in fact, as you may know, the Bell Lecture was conceived of by Janet as a gift for Derek's 65th birthday. It's not surprising that she would think up such a compelling event, given her own professional and personal commitment to education and to communication. Janet is a wonderful friend of this law school and to me, and we're thrilled to have her with us tonight. Without further ado, Dr. Janet Bell.
Thank you, and good evening. Dean Morrison has been such a wonderful successor to a number of wonderful deans at this school, and it's always a thrill to see him And it's always wonderful that he supports this lecture very enthusiastically every year. Thank you for that. I'm trying to move this mic down just a little bit because Dean Morrison is a couple inches taller than I am without dropping it, so bear with me a second. Derek loved and lived to teach, and teaching kept him alive. For him, it was always students first. It was a mantra in our household. In that universal encyclopedia in the sky, his portrait is the definition of mentor. For him, there was no higher calling than teacher. It is always gratifying and humbling that students who are not his students, Derek died 7 years ago, this past October, but many students here now consider themselves his students. They continue his work with integrity and dedication. I too want to acknowledge the 3 Bell sons, Derek Bell III, Douglas Du Bois Bell, and Carter Robeson Bell. There is significance in those names. Carter is the family wit, and he often says he has 3 last names. Carter being in honor of Derek's mentors, Robert L. Carter and his wife, Gloria Carter. The late Judge Carter argued the first Brown v. Board of Education case before the Supreme Court and taught at this law school. Derek's other mentor, by the way, was the late civil rights attorney and judge, Constance Baker Motley. I especially and always want to lift up the memory of Derek's first wife, a phenomenal woman, Jewel Hairston Bell, who died before Derek and I met. She left a great legacy and a great responsibility to carry on her work. As partners, she and Derek set the standard. Now, 20 years ago, over 20 years ago, 23 to be precise, the Bell Lecture and co-founders shared a dream with me. It was not just me. It included Judge Robert L. Carter, Paulette Jones Robinson, and Valerie Kavanaugh and Bill Kerstetter, William Kerstetter, who are here tonight. They always fly all the way from California for the Bell Lecture. Where are you guys? Don't be shy. Also included in our village is the international lawyer Alice Young, one of Derek's first students at Harvard Law. She, along with Charles Ogletree, helped endow this series. Also, Lisa Marie Boykin, class of '95 of NYU Law School, with recent assists from Dr. Kitty Muldoon Steele and Louis Steele, as well as Ted and Nida Wells. I always want to thank them, and Kitty, I know you're not shy. And deep personal thanks to the former dean and former university president, John Sexton, who was a Bell student at Harvard, who championed this lecture series from the beginning, and to his successor, Ricky Revesz. With thanks too to the Law Alumni of Color Association and its president, Rafiq Kalimuddin. Now, these things don't just happen by themselves, so I'd like to give special thanks to the staff of the Office of Development and Alumni Relations for their care and their attention to this lecture series, with special acknowledgement to Kelly Spencer for always going above and beyond the call of duty. So on behalf of the Bell extended family, I again pledge our continued support to this fine law school, represented in part by this lecture series and the courtyard bench with a plaque in Derek's honor. That bench, by the way, which is out front, you students, please go out there and contemplate ways that you can help save our fragile democracy. And of course, I get a kick every year. Thank you. In introducing one of the most humble and shy people outside of the classroom and the courtroom I know, and that is the Vice Dean, Randy Hertz. He's the faculty liaison for the Bell Lecture Series since Derek's passing. Students love Randy, as do I. As with Derek, Randy Hertz is student-focused, I say student-obsessed. He is also a true gentleman and a scholar. I'd like to acknowledge someone else who's in this room tonight, a former Bell scholar, and that is William Chip Carter of the University of Pittsburgh, who at that time was the dean of the University of Pittsburgh, who spoke a few years ago. Thank you for coming, and he comes all the time to support this series. The University of Pittsburgh was where Derek earned his law degree in 1957, where he was on law review, of course. So, it's my pleasure to introduce someone who needs no introduction to this law school, but to those of you who are part of this community and part of our extended family, let me tell you a little bit about Anthony Tony Thompson. He is a great professor, great scholar. He's also the founding faculty director for the New York University Center on Race, Inequality, and the Law, and they've been slamming for the last couple years. He is a renowned professor of clinical law. He teaches courses related to criminal law and litigation. His scholarship focuses on race, offender reentry, criminal justice issues, and leadership. His book, Releasing Prisoners, Redeeming Communities, is an in-depth look at the issues of poverty, reentry, race, politics, and media. His teaching awards at NYU include the Podell Distinguished Teaching Award and the university's Distinguished Teaching Award. He also received the L Award from El Diario for his community service. Now, the reason we started with music, most of you know Derek loved music, and almost every Bell event has music. I'm so grateful that an ensemble from our church choir, First Presbyterian Church, Brooklyn Heights, was able to join us tonight. They also sang at Derek's memorial service, so they are very close to our heart. The Minister of Music is Amy Nooner, and Derek used to say, for a little person, she has such big energy, and that is true. Now, every year, we sing Happy Birthday to Derek because it's also a celebration, even though we deal with weighty issues. But as the music buoys us and as culture moves us forward to fight the battles ahead, we must embrace music, right? And so, but every year, some of you do not get the memo that we're doing the Stevie Wonder version of Happy Birthday. So I'm going to ask Stephanie Seymour from the choir, First Presbyterian Church, to come on up and help me sing this song, because tonight is more than a lecture. It is a celebration of Derek Bell's exemplary life of meaning and worth. And so, in recognition of that, happy birthday, happy birthday, happy birthday, happy birthday, happy birthday, happy birthday, happy birthday.
Good evening. It's a tough act to follow. Derek was my mentor, my friend, and my colleague. I learned a lot from him. And his writings about the permanence of racism in American culture was less a pessimistic tone, but rather a railing against bigotry, racism, and white supremacy. But Derek, in fact, was a man of great hope, great passion, and great faith. One of the things that I learned in his passing, I taught his classes in that last year, was that with his fellows, his teaching assistants, and the legion of people he launched into legal education, Derek had a profound respect for women. And in fact, looking down on us from heaven today, he would look at Professor Melissa Murray and Professor Deborah Archer as wonderful additions to this community. Not to mention the awesome new dean at Boston University School of Law. But Derek, being Derek, would say, there's still work to do. What about the Latinx professors? What about the Asian professors? What about the young men of color? We still have work to do. In my own work on leadership, I've learned that putting together an important leadership team requires you to think hard and get strong people. In this last 2 years, the Center on Race, Inequality, and the Law has made its mark. We've been active in the national criminal justice reform landscape. We've taken a unique position in the positions of race and technology. And our convenings have brought people together to foster critical conversations nationally. All that is due in large part to my team. Our esteemed fellow, Sarah Hamilton, our wonderful student fellows and volunteers, but perhaps most importantly, the spine of the center, Vincent Sutherland. I've known Vincent for a very long time. He cut his teeth as a public defender, looking at the effects of the criminal justice system on our nation, our communities, and our young people. He took those skills to the NAACP Legal Defense Fund and became one of the premier civil rights litigators in the nation. I've had a chance to see him grow, and in the last year, watch him in the classroom. He's been amazing. And I've seen that he's as great in the classroom as he is in the courtroom. He's had an opportunity to inspire, to teach, and to challenge our young people, our law students here. So I am quite pleased to introduce the Executive Director of the Center of Race, Inequality, and the Law, Vincent Sutherland.
Good evening. And thank you so much for that warm introduction, Tony. I have the distinct honor of introducing tonight's lecturer, Angela Onwuachi-Willig. As is typical of her brilliant scholarship, the title of her lecture, The Tragedies of Emmett Till and Trayvon Martin, illustrating Professor Bell's lesson on how racial patterns adapt in ways that maintain white dominance, pulls together American history, contemporary events, critical race theory, and the law. It's so very helpful in times like these to hear from someone who can help us make sense of the world around us and all its racialized complexity. Her lecture promises to be both dynamic and enlightening, and I cannot wait to hear it. But before we get there, please allow me to tell you a little bit about our esteemed guest. She was born and raised in Houston, Texas, the same Houston, Texas, by the way, that just elected 19 black women to the bench. She previously served as a Chancellor's Professor of Law at the University of California, Berkeley. Before that, she served as a Professor of Law at the University of Iowa College of Law for nearly a decade, and as an Assistant Professor of Law at the University of California, Davis. Those positions were preceded by a pair of federal clerkships and time spent as a labor and employment lawyer. In August of 2018, Angela, to great fanfare, assumed her current position as the Dean of Boston University School of Law. Angela's ascension to her current position as the dean of a top-flight law school is the latest accomplishment in a legal career overflowing with phenomenal accomplishments. She's recognized nationally as a top-notch legal scholar and an expert in civil rights, race, gender, inequality, and critical race theory. Her scholarship is nothing short of profound. It speaks to the things that truly matter, the things that students don't often get to focus on in law school, the people in the footnotes and at the margins, whose experiences, whose lives, whose race, whose gender, whose class shape the outcomes of the cases that comprise the law. Her scholarship is also prolific, and I mean prolific. She's published extensively in the most respected law journals and publications nationwide. In fact, if you take a look at her CV, the portion of her CV that lists all her academic publications and all her conference appearances and all the other contributions she made to scholarship is long enough to meet the requirements for a nice law review article itself. In all seriousness, Angela is an intellectual force of nature. And while all that's well and good, the reality is that she brings so much more to the table than her incomparable intellect. The truth is that she's an inspiration to others. She's a mentor, an absolutely exceptional leader, and someone who has dedicated her career to shaping the minds of those who will define the law and the legal profession for generations to come. Her outstanding teaching and her service to students has been recognized time and again and award after award at every institution that she has been a part of. She's been especially invaluable in championing diversity in the academy and serving on and chairing national committees to develop the best practices for recruitment and retention of law teachers of color. Melissa Murray, who I'm proud to say joined the faculty here, is a firsthand witness to Angela's gifts. You see, Melissa was on her way to Berkeley and excited to have Angela as a colleague. Unfortunately, when Melissa arrived, Angela left promptly for Iowa. Fortunately for Melissa, Angela founded the Lutie Little Black Women Law Faculty Workshop, which has produced countless articles and books and has assisted dozens and dozens of women on the path to tenure. Melissa took advantage of that workshop and attended it in Iowa. And she shared with me that there was very little at the time that could get her to come to Iowa, but Angela was there, and so she went. In my book, that speaks volumes about Angela's influence. But what's incredibly special to me is even with all that influence, all those professional accomplishments, whether it's prestigious awards or wonderful publications or even being named the finalist for the Iowa Supreme Court, all that's accompanied by an unparalleled level of humility and kindness that make her the paradigm for those in the academy and the legal profession, students and teachers alike, to learn from. It's also not lost on me how profound and how wonderful it is to see where she is today. Know how hard it was for her to get there. And another time, about 30 years ago, at another law school in the Boston metropolitan area, Derek Bell took an unpaid leave of absence from a prestigious institution until it hired a tenured woman of color on his faculty. As you can imagine, it was a stance that was not popular at the time. It was fraught with controversy. It was one that jeopardized his career. That school refused to change its ways at the time, which happily for us brought Professor Bell to this institution. Their loss, our gain. But I'd like to think that the other significant part of Derek's sacrifice, his courageous choice, was to contribute in some small measure to the success of incredibly talented, brilliant women of color like Angela, who continue to thrive at institutions and in the legal profession nationwide. I can't imagine how proud he must be of you tonight. It's such a great honor to welcome you as you add another chapter to an incredibly storied legal career by delivering this year's Derek Bell Lecture. Please join me in welcoming Angela Onwuachi Willig.
Wow, I want to thank you for that incredibly warm and kind introduction. Thank you so much. I also want to start by thanking Dr. Janet Dewart Bell for granting me this enormous honor of giving the 23rd annual Derek Bell Lecture on Race in American Society. Like the late Professor Bell, Dr. Dewart Bell, particularly through her new book, Lighting the Fires of Freedom, African American Women in the Civil Rights Movement, Dr. Dewart Bell has been a model for me in my own research and scholarship, showing me why it is so important for those of us with a voice in academic and public circles to use our voices to amplify the lives, the work, the challenges, and the sacrifices of those who are too often overlooked and undervalued in our society. And I want to thank Dr. Bell for continuing to be a model and an inspiration for me and for so many others in the struggle for equality and justice. I also want to thank Professor Bell's children, Carter Douglas and Derek III, for joining us in this event to honor their father. And in particular, I want to thank you for sharing your father with us throughout his life. We are so, so grateful for all that he has done for me, for countless professors, and I'll talk a little bit about what Professor Bell did for me. Additionally, I want to thank NYU School of Law for providing a forum through which the work and the legacy of Professor Bell can be honored and remembered each year, and just as important, for working with Dr. Dewart Bell to begin this tradition during Derek Bell's life, so that he had the opportunity to see and hear in a formal setting the great impact of his life and his work. And I want to thank Professor Tony Thompson and Vince Sutherland and Sarah Hamilton from the Center on Race, Inequality, and the Law for their work on this wonderful event. I'm grateful for everything that you have done. And I want to thank Dean Morrison for giving me this opportunity to honor one of my heroes. And finally, I want to thank Kelly Spencer, Associate Director of Alumni Relations at NYU Law, for all of her hard work in making this program a reality and in making my presence here possible. And of course, I want to thank all of you for being here for this very special event. As I said earlier, I'm tremendously honored by this opportunity to give the Derek Bell Lecture. One of the greatest achievements of my life was receiving the AALS Minority Group Section Derek A. Bell Award as a junior faculty member. I felt and I feel so honored by these connections with Professor Bell, not only because of the path that he blazed and opened for all of us as one of the first African-American professors at a majority school in the legal academy, and as the first tenured African-American professor at Harvard Law School, but also because of the pivotal role that he played in my life, both before I personally knew him and after I had the pleasure of meeting him. Were it not for Professor Bell, I would not be standing here before you as a lawyer and a law professor. In 1994, before I'd even personally laid eyes on Professor Bell, he, through his work, convinced me to remain in law school. Although I arrived at law school during the second and arguably the third generation of critical race theory, or the CRT scholarly movement, I had no idea what that scholarly field was at that time. And to be honest, I had no real idea what it meant to be a lawyer. All I knew is that I wanted to learn about the law to use it as a tool for combating the injustices I had both seen and read about in my life. Immediately before my first year of law school, I attended an orientation program at my law school, the University of Michigan. And that program was geared towards students of color and other underrepresented students in the law. And during this program, I expected to find students who shared my same passions. But while there were some students who shared my concerns and passions, the majority of them did not. And I began to feel alienated. And in fact, I felt somewhat alone. And naively, I wondered, well, if even the students of color are not as concerned about justice and social change as I am, is law school really the place for me? Was there a place for me in the law? And I began to wonder if I should leave law school. Luckily, during that same program, I had the pleasure of meeting a group of 2Ls who were part of a CRT reading group. And they introduced my classmates and me to CRT, starting with Professor Bell's seminal piece, Space Traders, a fictional story about the process by which the US government ultimately decided to accept an offer from aliens to trade all blacks in return for gold, to bail out the almost bankrupt federal, state, and local governments, special chemicals capable of unpolluting the environment, and a totally safe nuclear engine and fuel to relieve our nation's all but depleted supply of fossil fuel. So prescient, right? The story Space Traders captured my attention like nothing else that week. It spoke to my experiences as a Black Southern woman from an economically disadvantaged background in the United States, and it helped to fill the void of silence about race that had seemed to be far too wide in this program, and frankly, throughout much of law school. It was only after reading Space Traders that I became certain there was a place in the legal profession for me. I distinctly remember thinking that if a tenured law professor from then Harvard Law School could write this story, there must be a place in the law for me. And ultimately, that CRT reading group led my classmates and me to form the Michigan Journal of Race and Law the very next year. And since then, 6 of us from this founding group have become law professors, all engaged in scholarship about race and law. As a professor, each time I taught my critical race theory course, I always assigned Space Traders as the first reading, sharing with my students the personal importance of the piece to me, as well as the ways in which it challenged traditional notions about what legal scholarship must look and read like. And every year, Space Traders was one of my students' favorite readings. The story simply never got old. And while there was always disagreement and debate about whether our nation would ever accept such a trade from aliens if presented, the majority of students in each course agreed with Professor Bell, meaning they always believed that the United States would in fact trade all of its African Americans for these treasures. And they did so even after we had elected the nation's first Black president, Barack Obama. And of course, Professor Bell was incredibly generous when I actually became a professor. When I was a junior faculty member, I would send many of my drafts to him, and he always read them, sending back lots of really amazing and incredible comments that enriched my work. And it was through the Michigan Journal of Race and Law that I first met Professor Bell. Professor Bell was always so gracious in supporting the efforts of law students and aspiring attorneys. So it should come as no surprise that he was kind enough to support the effort of students who are looking to provide yet another space for race scholarship in legal academia. He did so by agreeing to be the opening keynote speaker for the first symposium for the Michigan Journal of Race and Law. And lucky for me, I had the privilege of being Professor Bell's host during his entire stay. I learned much from him during those couple of days, and he was, of course, encouraging of my goal then of becoming a law professor. And once Professor Bell returned to NYU, he kindly sent me a handwritten note to thank me for serving as his host and to offer me additional encouragement about my goal of becoming a law professor. I was floored when I received it. I could not believe that this superstar scholar had taken even a minute to draft a thank you note to me. But that was Professor Bell, brilliant and highly accomplished, but also generous, humble, and down to earth. But what I remember most from that moment in hosting Professor Bell is how he took one example from everyday life, both his and mine, to impart a lesson about racism to students at our inaugural symposium. The morning before Professor Bell was set to give his opening keynote address, I went to his hotel to pick him up and bring him to the law school. I parked and then met Professor Bell in the lobby, and we proceeded to the front desk so he could check out of the hotel. Working at the front desk was a white woman who looked to be in her 30s or so. And ahead of us was a customer who was also white, whom she called up to the desk so she could check him out of the hotel. Professor Bell and I should have been the next people in line to receive service, but we did not. Instead, before the hotel guest ahead of us had finished checking out that guest, another guest, also white, came up and stood to the side ahead of us. I thought this customer's move was a bold one, but I was certain that the woman who was working at the front desk would wave us over for service first. After all, she had seen us behind the customer she was helping at the time and had to know that we were there before the man who was trying to cut us in line. Or perhaps even sadder, the man who had rendered us invisible and did not even realize that he was cutting us in line. Instead, when the young woman finished helping the first customer, she made a gesture asking the line-cutting man to come forward to the front desk. I was upset by her action, but I would have forgiven her for it, perhaps even convincing myself that she had not actually seen us, if she had not later waved over a white couple who had literally just arrived downstairs right after she finished assisting the line cutter. In my youth, I was ready to tell the woman about herself. And I was ready to do so not because I was surprised to be encountering racism, but rather because she was disrespecting one of my heroes. I expressed my anger to Professor Bell, indicating my intent to call the hotel employee on her racism, but Professor Bell calmly told me to let it go. And when she finally waved us over, because there was no one else for her to use to avoid serving us, Professor Bell, of course, was kind and respectful to her. We checked out and then headed to the law school. In the car, I apologized for the poor welcome that Professor Bell had received in my law school hometown. And Professor Bell again told me not to worry, even expressing an understanding of the forces that may lead someone in that woman's position to engage in such obvious disrespect and racism towards us. And I thought that was the end of the story. But when Professor Bell took the podium to give his lecture, he eloquently recounted the indignities that he and I had experienced in the morning and used them to offer a lesson to illustrate his point about racism, its permanence, and its adaptations over time. This initial lesson that Professor Bell offered in his lecture was one that he'd previously written about in his seminal book, Faces at the Bottom of the Well, in 1992. He so poignantly wrote, quote, "Black people will never gain full equality in this country. Even those Herculean efforts we held successful will produce no more than temporary peaks of progress, short-lived victories that slide into irrelevance as racial patterns adapt in ways that maintain white dominance." And later in his article, The Racism is a Permanent Thesis, Courageous Revelation or Unconscious Denial of Racial Genocide, Professor Bell provided a summary of his arguments from Faces at the Bottom of the Well, explaining that racism is a, quote, critically important stabilizing force that enables whites to bind across a wide socioeconomic chasm, end quote. And today, here we are in 2018, with racism continuing to adapt and evolve despite peaks in progress, like the election of our first Black president. And here we are, near the end of 2018, watching with fear from the sidelines as our leaders, including our commander-in-chief, employ racism as an important stabilizing force that enables whites to bind across a wide socioeconomic chasm. So today in my talk, the tragedies of Emmett Till and Trayvon Martin, illustrating Professor Derek Bell's lesson on how racial patterns adapt in ways that maintain white dominance, I used two case studies, one from the pre-civil rights era in 1955 and one from the post-civil rights era in 2012 and 2013 to demonstrate how old racial patterns can and have merely adapted to newer, more subtle patterns that work to maintain white dominance. Today, far too many people argue that racism is a thing of the past, and as proof of racism's disappearance, these individuals point to formal equality in the form of laws on the books that prohibit explicit discrimination on the basis of race, and that allow for the prosecution of individuals who engage in clearly racially motivated violent attacks. Additionally, they note that today's residents of the United States would condemn the use of racial slurs, and most would profess a belief in racial equality. However, as Professor Bell so wisely taught us, the fact that racism operates in different ways today than it did in the past, the fact that racism is more subtle than it was in the past, or the fact that much of racial discrimination is structural and in some respects is more likely to stem from non-conscious rather than conscious bias, does not mean that racism is not present. It does not mean that racism is not a current and pressing problem in our society today. And in this lecture, I seek to illustrate this point by showing how the same race-based forces and the same racist tropes that worked in the past, a past that we do not and cannot deny was steeped in the ugliest forms of race hatred, are still operating in contemporary society. And I do so by taking what many view as an extraordinary case about racial hatred from the 1950s, the Emmett Till murder and trial, and comparing it to the Trayvon Martin killing and trial in 2012 and 2013, respectively. And in so doing, I show how the power of the stereotypes that undergirded the Till case remain quite ordinary today. At the same time, I highlight a very subtle difference in the operation of these forces and tropes by showing how the two cases, the Till and Martin cases, reveal a movement from the Jim Crow era of protecting whiteness as property in and of itself to a post-civil rights era protecting what sociologist Elijah Anderson calls the white space. In all, I argue that the Till and Trayvon killings and trials centered on the policing of boundaries of whiteness. And thereafter, I take a step back to very briefly examine yet another commonality between the Till and Trayvon case, the cultural trauma, meaning the group-based trauma experienced by African Americans due to the acquittals in these trials, and more so what I've identified as a very pattern of actions that repeatedly bring us to this form of cultural trauma for African Americans. In so doing, I ask and answer, What is the cycle, if any, that creates and recreates the group-based trauma that African Americans experience, not only after police and quasi-police killings of non-threatening and unarmed African Americans, but more so, the trauma that arises after official legal responses that have consistently communicated to society that Black lives do not, in many ways, matter under the law. In one of my current book projects, I refer to this pattern or routine as the new status quo. But before I delve into my argument, I want to provide a refresher on the evil that found its way to Emmett Till in 1955. And while I'm certain that most of you do not need a reminder about what happened to Trayvon Martin in 2012, I believe it might be helpful to provide some basic facts about what happened to Emmett Till. So what happened to Emmett Till? At approximately 2:30 a.m. on August 28, 1955, two white men, J.W. Milam and Roy Bryant, invaded the house of preacher Moses Wright, an elderly Black man who was hosting Emmett Till, his 14-year-old grandnephew from Chicago, Illinois, at his home in Leflore County, Mississippi. After hearing through the rumor mill that Till had allegedly wolf whistled at Roy Bryant's wife, Carolyn Bryant, Milam and Bryant abducted the young Till with plans to teach him a good lesson. And in fact, their lesson would be Till's very last, because Milam and Bryant would beat, maim, and torture the young boy so badly that his father's ring, which Till wore during his trip to Mississippi, was the only clearly identifiable item on his person. And I want to warn you, I'm going to show you the picture. Let me tell. In her autobiography, Death of Innocence, the story of the hate crime that changed America, Till's mother, Mamie Till Mobley, described what she saw when she had to identify her only son's body. She wrote, "When I got to his chin, I saw his tongue resting there. It was huge. I never imagined that a human tongue could be that big. Maybe it was the effect of the water since he had been in the river for several days, or maybe the heat. But as I gazed at the tongue, I couldn't help but think that it had been choked out of his mouth. I forced myself to move on, to keep going one small section at a time, as if taking this gruesome task in small doses could somehow make it less excruciating. Step by step, as methodically as his killers had mutilated my baby, I was putting him back together again, but only to identify the body." Now, state officials in Mississippi tried to convince Till Mobley to conduct burial services in Mississippi, and she refused, insisting that they send her son's body to Chicago. And eventually, they complied with her demands. They sent Till's body back to Chicago, but they told her, "Don't open the casket. We've sealed his body in this casket and don't open it." And hundreds of miles away in Chicago, Till Mobley, whose family's roots were in Mississippi, but who had lived in Chicago and gave birth to and raised her son in Chicago, defied their orders and opened up the casket. And horrified by what had been done to her son, she decided she wanted the world to see what race hatred truly looked like. She held a 4-day open casket memorial service in Chicago. More than 100,000 people chose to attend the service, with another 2,500 people attending the actual funeral. She also allowed the Black press to both photograph her son's mutilated face and body and publish the pictures on the pages of their magazines and newspapers. And images of the disfigured young Till ran in Jet Magazine, the Chicago Defender, the Pittsburgh Courier, the New York, Amsterdam News, and the Crisis. And with this press, Till's murder garnered a significant amount of attention and outrage from both Blacks and whites, particularly in the North. And this outrage began to grow just about the same time as the unthinkable occurred. The September 5th, 1955 indictment of Milam and Bryant, two white men for the murder of Till, a Black boy, by an all-white male jury in Mississippi, and one mostly consisting of planters. And although Milam and Bryant admitted to kidnapping Till from his uncle's home, on September 23rd, 1955, an all-white and all-male jury in Tallahatchie County, Mississippi, acquitted the two white men of the murder charge for Till's death. And their decision took only 67 minutes. And one of the jurors afterwards said that, in fact, if they hadn't taken a break to have a Coke, it would have been even shorter. One underappreciated dimension of the murder of Emmett Till is that it occurred against the backdrop of the 1954 U.S. Supreme Court decision in Brown versus Board of Education. And what Till's murder shows us is that Brown not only engendered anti-racist solidarity among blacks, it also produced, as Professor Bell taught us, racist cross-class solidarity among whites because of the property value of whiteness. Emmett Till arrived in Mississippi during the summer of 1955 to visit family members only a year after the Supreme Court had issued its decision in Brown 1, and just a few months before Brown 2. Just a few months after Brown 2, excuse me. And more importantly, he arrived in the middle of a Southern revolt and backlash against the decisions and the change that they promised. To many white Mississippians, Northern Till, just by his presence, represented a threat to the social order, particularly since so many of them were still reeling from the Brown decision. J.W. Milam and Roy Bryant were among those whites who were desperately fighting to maintain their way of life in Mississippi. As whites who were subsisting at a level just above white sharecroppers, Milam and Bryant had come to place a high value not only on the material benefits that their whiteness granted them over African Americans, but more so on what W.E.B. Du Bois and legal scholars such as Cheryl Harris have defined as the psychological wages of whiteness, the compensation they received in the form of knowing that they would not fall to the bottom of the social hierarchy so long as blacks remained there. The best evidence of how the protection of whiteness and its attendant status and privileges served as a motivation for Till's murder came directly from Milam's mouth. After Milam and Bryant were acquitted, Milam bragged about murdering Till to journalist Bradford Huey, who later published an article with the confession in Look magazine. And Milam began his confession to Huey by expressing his desire to keep blacks in their place so that they would not exercise their right to vote. He proclaimed in part, "I like N-words in their place. I know how to work them, but I just decided it was time a few people got put on notice. As long as I live and can do anything about it, N-words gonna stay in their place. N-words ain't gonna vote where I live. If they did, they control the government." So it's significant but not surprising that Milam referenced his troubles with the idea of political participation by blacks in his confession. After all, concerns about blacks voting in the area had been growing ever since the Brown decisions. And although blacks made up the vast majority of residents in both LaFleur and Tallahatchie counties, whites have been able to maintain control over both counties by preventing blacks from registering to vote, including by killing those who dared to register to vote. In fact, no blacks were eligible to serve on the jury in the murder trial against Milam and Bryant because service on the jury depended upon eligibility to vote, and no blacks were registered to vote in Tallahatchie County at all. And in fact, no one could remember the last time that an African American was registered to vote in Tallahatchie County. So in his confession, Milam revealed not only his concern with blacks voting in elections, but also his knowledge that blacks, given that they were numerically the majority in Mississippi, and in particular in his county, could control politics if they had a real opportunity to vote. The strongest evidence of Milam and Bryant's desire to protect the wages of whiteness came near the end of Milam's confession, where Milam repeatedly referred to Till as being a Northerner, and where Milam complained over and over that Till simply refused to capitulate to the understood racial hierarchy of Mississippi. Milam ended his confession declaring that he had no choice but to murder Till in order to make an example of him for Northern blacks and any others who might even question the way of life in Mississippi. He said, "Well, what else could I do? Me and my folks fought for this country and we got some rights. I stood there in that shed and listened to that N-word throw that poison at me, and I just made up my mind. Chicago boy, I said, I'm tired of them sending your kind down here to stir up trouble. God darn you, I'm gonna make an example of you, just so everybody can know how me and my folks stand." And even before that, Milam had subtly noted one way in which Till had already broken the unwritten rules of the South, a transgression that ended up depriving Milam and Bryant of one of the few signs of respect based on whiteness that they, as part of the white working poor, received in their daily lives, being addressed as sir or mister by blacks. Raised in the North as opposed to the South, Till was not accustomed to racialized ways of communicating between whites and blacks in Mississippi, just referring to all whites, including white children, as Mr., Mrs., Miss, Sir, or Ma'am. And as a result, when Milam and Bryant woke up Till and his relatives from their sleep at 2:30 a.m., and they shouted orders at him, a groggy Till, unlike his uncle, did not respond with a customary yes or no, sir. Huey's retelling made it clear that Milam felt insulted by Till's failure to abide by these rules. He wrote, Big Milam shined the light in Bobo's face. Till, you the N-word who did the talking? Yeah, Bobo replied. Milam, don't say yeah to me. I'll blow your head off. Get your clothes on. And in fact, Till is so unaware of what's happening that they're telling him to get his clothes on and get rushing, and he's saying, I've got to put my socks on, because you can't put on your shoes without socks. Right. Making plain his measure of the psychological wage that whiteness offered him, as well as his disdain for anyone who might even think to suggest that any black was as good as a white man, Milam proclaimed, we were never able to scare him. They had just filled him so full of that poison that he was hopeless. If Milam's comment about his inability to rid Till of his poisonous thoughts were not enough, Milam's confession indicates that it was Till's alleged belief that he was equal to him that ultimately made him pull the trigger. Huey wrote, Big Milam ordered Bobo to pick up the fan. He staggered under its weight, carried it to the river bank. They stood silently, just hating one another. Milam, take off your clothes. Slowly, Bobo pulled off his shoes, his socks. He stood up, unbuttoned his shirt, dropped his pants, his shorts. He stood there naked. It was Sunday morning, a little before 7. Milam, you still as good as I am? Bobo, yeah. That big .45 jumped in Big Milam's hand. The youth turned to catch that big expanding bullet in his right ear. He dropped. Right? So I want to also note that Mamie Till Mobley argued that this couldn't possibly be true. I mean, obviously it's true that he shot Till, but she's, if you look at the picture of Till, she's doubting that he could have been standing still, that he would have been staring at anybody else. So I wanted to note that because she has questioned the argument. Many other white Mississippians, Milam simply was not ready and willing to give up even the arguably meager compensation that whiteness provided him. But much more was at stake than the protection of whiteness and its attendant privileges for these two men, Milam and Bryant. For white Mississippians as a whole, whiteness and the social significance that it would have for their own place in a post-Brown world was in danger. Against the backdrop of the change the Brown decisions threatened to bring, Till, or rather the criticisms and attacks that came from Northerners upon his death, ultimately came to represent a threat to white Mississippians' segregated way of life. To protect segregation and the benefits it yielded them, many white Mississippians, despite their initial reaction, to distance themselves from Milam. So initially, the governor comes out and says this is a murder. People are condemning. The Milam and Bryant have a hard time even getting any attorneys, right? But as there's more and more criticism from the North, the white Mississippians come around to protecting the two known murderers with the resources of a vigorous defense by all 5 attorneys in town, and ultimately with their complicity in a not guilty verdict. Further proof that white Mississippians were motivated more by their desire to preserve the property value of whiteness than any desire to protect Milam and Bryant as individuals was the manner in which white Mississippians deserted Milam and Bryant when they were no longer at risk of any further charges. Once they were no longer worried that a conviction of Milam and Bryant can function as an indictment against their racially segregated way of life, they left the two men to suffer on their own. As Huey would report 1 year later, in an article entitled What's Happened to Emmett Till's Killers, both Milam and Bryant suffered severe personal consequences after the trial, though neither would ever be incarcerated or suffer any other legal punishment. So first, boycotts by blacks resulted in the actual closing of all 3 stores the Milam and Bryant families had operated for years, stores that had been very dependent upon trade from African Americans. Upon his store's closing, Bryant had trouble getting a job and ultimately went to welding school, an act which Milam claimed would be of no help to Bryant and his family because, quote, by the time you've learned it, you've ruined your eyes, end quote. Additionally, Milam, who prior to the murder had employed blacks to operate his mechanical cotton picking machines, could not find any blacks who were willing to work for him after the Till murder and confession. So he was compelled to hire white men whom he had to pay higher wages. And in the end, Huey summed up the thought to Milam, who still a year later held no remorse for murdering the young Till, as follows. So Milam is confused. He understands why the Negroes have turned on him, but he feels that the whites still approve what he did. Why then should they be less cooperative when they were patting him on the back, contributing money to him, and calling him a fine, red-blooded American? And Milam himself proclaimed, "I had a lot of friends a year ago. Everything's gone against me, even the dry weather, which has hurt my cotton. I'm living in a sharecrop with no water. My wife and kids are having it hard." So in essence, once defending Milam and Bryant was no longer tantamount to defending the state's system of segregation, no white Mississippians cared about the fate that the two men would suffer. Excuse me. Like Till, Trayvon Martin, who had just turned 17 years old in February of 2012, found himself visiting family in a strange new town that month. Following a 10-day suspension from his high school, Martin's father, Tracy Martin, brought his son to Sanford, Florida, which was 4 hours away from his mother, Sabrina Fulton's home in Miami, Florida. And not just Miami, Florida, but Miami Gardens, Florida. So it's a town with a black mayor, a mostly black city council, a black police chief, and so on. This is where Martin grew up. And Martin had been suspended for having a baggie that had marijuana residue in his school bag. And the reason for bringing Martin to Sanford was to prevent him from using his time away from school during his suspension unproductively by simply hanging out with friends in Miami. On the night of the fatal shooting, Martin was a guest at the home of his father's girlfriend, Brandy Green, a black woman who was renting a townhome in a neighborhood called The Retreat at Twin Lakes in Sanford, Florida. At approximately 7:15 p.m. on February 26, 2012, Martin was returning from the local 7-Eleven after a candy and soda run to Green's home in The Retreat at Twin Lakes, the gated community where both Green and George Zimmerman lived. And likely due to the rain that night, Martin pulled the hood of his black hoodie over his head as he spoke to his friend, Rachel Jeantal, on the phone. At the same time, George Zimmerman, who was the captain of the gated subdivision's Neighborhood Watch program, was driving to Target in his SUV. And when he spotted Martin in the rain, Zimmerman made a 911 call to report Martin as a suspicious person. And despite being instructed by the 911 operator to remain in his vehicle, Zimmerman, who was carrying a gun, failed to follow these directives. He continued to follow Martin and ultimately confronted the teenager. And the next thing that Jeantal heard was Martin asking, "Why are you following me?" And then she heard a voice say, "What are you doing around here?" Following that, Jeantal heard what she believed was another person pushing Martin, Martin's phone crashing to the ground, wet grass sounds, and then Martin saying, "Get off, get off." For a short while longer, Jeantal heard arguing in the background, and then the phone line went dead. So only Martin and Zimmerman know what transpired after that point, but one undisputed fact is that Zimmerman shot and killed Martin, who was an unarmed guest of a resident in that same gated community. Martin had nothing on his person but his cell phone, an Arizona watermelon soda, a bag of Skittles, $40.15 in cash, a cigarette lighter, and some headphones. And much like Till when he came to visit his relatives in Money, Mississippi in 1955, Martin entered Sanford without any real knowledge of the racially tense environment that he was entering. And Sanford has this infamous racial history. In fact, it's the town where Jackie Robinson was run out of town not just once, but twice, right? At the time, the year before, there had been a previous shooting by a police officer of a young black man, and the evidence showed that he had been moving away from the officer when the officer said he had been coming toward him. So there was a lot of tension in the town. So what Martin did not know is that he was walking in a neighborhood where residents, much like white Mississippians in 1955, were fighting to preserve the whiteness of their neighborhood, or rather the meaning accorded to white spaces that their neighborhood had previously claimed. Additionally, Martin had no idea that he would encounter a person like George Zimmerman, who, like Milam and Bryant, may have been working to preserve his precarious status within the neighborhood's racial and class-based hierarchy because of his status as a renter in a community that was increasingly hostile to renters and as someone who was part Latino. As numerous studies have revealed, whites are the most racially segregated group in the United States, and that reality is not by pure mistake or coincidence. On average, whites live in neighborhoods that are 74% white. And unlike whites, blacks, Latinos, and Asians are willing to live in a neighborhood in which they are the numerical minority. But more importantly, researchers have found that whites are the most segregated racial group in the country because they prefer to have only a few minority neighbors. For example, as the research of sociologists Maria Kreisen and Camille Zabrinsky-Charles has shown, prejudice is the strongest predictor of resistance to racial integration among whites, while fear of discrimination is the strongest predictor of blacks' avoidance of white neighborhoods. In fact, the work of scholars Richard Wright, Mark Ellis, and Steve Holloway reveals that diversity is a turnoff within white-dominated spaces for same-race white households. And another study revealed that diversity was one of the strongest factors in terms of negatively predicting the degree to which whites viewed neighbor relations as harmonious. As Andrew Hacker explains in his book, Two Nations, Black, White, Separate, Hostile, Unequal, many whites view living in neighborhoods with meaningful racial minority populations as being less than or inferior in terms of their social standing, and thus they work hard to police those boundaries. And at the time that Zimmerman killed Martin, his neighborhood, the Retreat of Twin Lakes, was undergoing a transformation, the kind of transformation that tends to push whites to police the boundaries of what Elijah Anderson calls the white space. At the time, the downturn in the economy had resulted in a change in the ratio of owners to renters, like Zimmerman at the Retreat of Twin Lakes, and there were more and more foreclosures happening. And along with foreclosures came a drop in the value of the townhouses in the neighborhood, with the homes that once cost buyers $250,000 falling to prices below $100,000. Additionally, a larger number of townhomes in the gated subdivision went empty. And the neighborhood at the same time was becoming more racially diverse. By 2011, residents of the neighborhood began to report an increasing number of burglaries to the police. And at that point, the tenor and pattern of 911 calls by Zimmerman, who had previously made many calls, but without a racial pattern, began to change. So Zimmerman before had been making calls, but it would be calling about somebody's dog that was barking too loud. But after these burglaries, all of a sudden, the suspicious individuals who became the subject of his calls had one thing in common. They were all black males. And in fact, he even once called to report a 7 to 9-year-old black male being in the neighborhood, and that was simply the call, that there was a kid in the neighborhood that was black. Overall, the Neighborhood Watch residents began their efforts to preserve the whiteness of the retreat at Twin Lakes, or at least the perception of the neighborhood as a white space, because it was actually fairly diverse. As Berthelon would later explain, people were freaked out. It wasn't just George calling the police. We were calling police at least once a week. She continued. There was definitely a sense of fear in the neighborhood after all this started happening, and it just kept on happening. It wasn't just a one-time thing, it was every week. Our next-door neighbor actually said if someone came into his yard, he would shoot him. If someone came into his house, he would shoot him. Everyone felt afraid and scared. But the fact that only 2 of the neighborhood's 44 burglaries, attempted break-ins, and suspected break-ins were confirmed to have involved black males supports the notion that the protection of whiteness, here the protection of white spaces, and the stereotypes of blacks were heavily guiding the actions of Neighborhood Watch participants like Zimmerman. It was not simply that Zimmerman and other Neighborhood Watch participants linked blackness with criminality, but that they viewed blacks who were in the spaces that they viewed as white, their neighborhood, as criminals, as outsiders who were up to no good. And in fact, long after it was shown that Martin, who had no criminal record, was simply walking back to the townhome where he was a guest of his father's girlfriend, Frank Taffy, a white resident in the neighborhood, insisted during a television interview that Martin was out of place in the neighborhood and should not have come near his home while he was away. Taffy's interview proceeded as follows. Frank, what made him look suspicious? What made him look suspicious in your mind? Just because he was walking through your yard? Taffy, he was out of place. George knew he didn't live there. He was out of place. He was out of place. Williams, he had a right to be there, Frank. Taffy, he's out of place. He's on private property. That's my property. Right? Taffy has since come out and says that he believes that George Zimmerman actually murdered Trayvon. And although as many as 8 burglaries within a year's time may reasonably concern many residents, in this instance, the concern seemed to be racialized in a way that was not corroborated by actual data, but rather by standard implicit biases. Professor Song Richardson has explained, studies show that just thinking about crime can trigger non-conscious thoughts about blacks, which in turn activates black stereotypes. And disturbingly, not only does seeing a black individual bring negative racial stereotypes to mind unconsciously, but simply thinking about crime triggers implicit thoughts about blacks in police officers and civilians alike. Additional evidence of the role that the protection of whiteness played in Zimmerman's viewing Martin as suspicious, following him and then killing the young boy, lay in the perceptions and experiences of residents of color at the retreat at Twin Lakes. And these residents either did not perceive the same problems as Zimmerman and other neighborhood watch participants, or they became the targets of the policing by Zimmerman and other neighborhood watch participants. People like then 25-year-old Ibrahim Rashada, a black man, had to alter their daily rituals because they no longer felt free to roam about in their own community. And they no longer felt free to do so when Zimmerman and other neighborhood watch participants began their policing with a focus on black males. So for example, instead of taking walks in his own neighborhood, Rashada began to take his regular walks downtown. As he explained, quote, "I fit the stereotype he," Zimmerman, emailed around. "A black guy did this, a black guy did that. So I thought, let me sit in the house. I don't want anyone chasing me," end quote. So much can be learned from comparing and analyzing the death and trials concerning Emmett Till and Trayvon Martin. This comparison raises questions about how far we have truly come when past injustices simply seem to emerge in new forms. Much like Professor Bell might have explained to us, the killing of Trayvon Martin and other police and quasi-police killings that have occurred in recent years are in many ways adapted forms of racism that previously took the form of lynchings, like the killing of Emmett Till. More so, as Professor Bell once explained in his article, Racial Realism, understanding these patterns and adaptations of racism and repeated discrimination is necessary if we are ever to devise strategies for eliminating their effects in society. In Racial Realism, Professor Bell directly contemplated the effects of repeated discrimination, explaining how we must acknowledge these realities as well as the limits of law if we ever want to truly change society. He wrote, quote, "Unhappily, most black spokespersons and civil rights organizations remain committed to the ideology of racial equality. Acceptance of racial realism concept would enable them to understand and respond to recurring aspects of our subordinate status. It would free them to think and plan within a context of reality rather than idealism. The reality is that blacks still suffer a disproportionately higher rate of poverty, joblessness, and insufficient health care than other ethnic populations in the United States. The ideal is that law, through racial equality, can lift them out of this trap. I suggest we abandon this ideal and move on to a fresh, realistic approach. Casting off the burden of equality ideology will lift the sights, providing a bird's-eye view of situations that are distorted by race. From this broadened perspective on events and problems, we can better appreciate and cope with racial subordination." So taking these wise words from Professor Bell into account, I've begun to delve into a larger project that considers how police and quasi-police killings of unarmed African Americans, and more importantly, how the legal outcomes in these cases can deepen our understanding about what sociologists have defined as cultural trauma, and more so about the patterns of conduct that bring us to these group-based traumas. Sociologist Jeffrey Alexander of Yale University defines cultural trauma as group trauma that, quote, "occurs when members of a collective feel they have been subjected to an horrendous event that leaves indelible marks upon the group consciousness, marking their memories forever and changing their future identity in fundamental and irrevocable ways." As a group, African Americans have experienced trauma, cultural trauma, not only in relation to killings like those of Emmett Till and Trayvon Martin, but also in relation to the acquittals that were handed down at the end of those trials, and more so, the non-indictments and acquittals that have seemed to become routine in our society. One of the ways in which such killings followed by repeated acquittals or non-indictments have traumatized African Americans is that they have left so many of us with an expectation of injustice in our criminal system, in our justice system. Consider the response of the family of Tamir Rice, the 12-year-old African American boy who was shot and killed while playing with a toy gun in Cleveland, Ohio. Consider the response after Officer Timothy Loman, the man who shot the 12-year-old child, within 2 seconds of his arrival on the scene, was not indicted for taking his life. Sasha Ginsburg, one of the attorneys for the Rice family, responded to the non-indictment by proclaiming, quote, "Tamir's family is saddened and disappointed by this outcome, but not surprised." Others, such as Reverend Jawanza Colvin, an African-American pastor at our Cleveland church who had pushed for Lohman's arrest, expressed similar sentiments. Colvin declared, quote, "The fact that we are not surprised by the grand jury's decision is in and of itself an indictment of the culture of the criminal justice system," end quote. And while such responses by the Rice family and other African Americans could be read solely as a pessimistic outlook on the justice system, they should instead be understood as measured responses to a sociological pattern of events and decisions that have developed in cases involving police and quasi-police killings of unarmed African Americans, a pattern that begins with a tragic killing or horrific beating of a non-threatening or unarmed African American that is frequently followed by an acquittal or non-indictment of the officer or quasi-officers who killed the unarmed victim, and that ends in cultural trauma and a sense of hopelessness and disappointment in the American legal system by African Americans. And in fact, in my work, I've identified 7 steps. Understanding these patterns of racism and how they have evolved and are evolving over time is critical if we are to devise ways for combating such structural and attitudinal problems in our society. As Professor Bell explained in his article, racism is here to stay. In spite of short-term advances in the civil rights movement, Black people, all people, must acknowledge how racial patterns adapt in ways that maintain white dominance. Only then can we be, quote, free to imagine and implement racial strategies that can bring fulfillment and even triumph, end quote. As he further explained, it is this, quote, acknowledgement of racism's permanence, which far from an invitation to ultimate despair, will serve as the opportunity for new insight, more effective planning, and perhaps renewed victory. Thank you. Thank you. Any questions?
We have a few minutes for questions if you'd like, and there are microphones in each of the aisles. So if you'd like to ask questions, please come to the mic.
Dear Angela,
How you
what a
doing?
magnificent set of reflections
Thank you.
on 1955 and Emmett Till, and more recently on Trayvon Martin. I just have a small question, which has to do with what strikes me as a huge difference between the killing of Trayvon Martin and the killings that you referenced
Right.
by police officers who are state officials, because it seems to me crucial to mark the, in some ways, more horrific reality that connects the Trayvon killing to the Emmett Till killing, in that these were civil society killings by white citizens.
Yeah.
Right? And the specificity of the connection between the two cases, I think, consists in the fact that we still live in a state, in a white supremacist state that effectively delegates
Yes.
to white private citizens the police power over black life and death, right? A kind of sovereignty, a dominion,
Yes.
right? So there's that spatial aspect,
Yes.
but there's also very much this idea that white citizenship consists of that interest, that political interest in necropolitics. So law, the state is an ideological weapon of death, but white citizenship itself in these instances shows itself to be and to consist of the killing of black bodies,
Yes.
of necropolitics as white Republican, racial Republican identity, and I use that word Republican deliberately, right? So what would you say about that tight fit, the tightness of the fit, uniqueness of it, which in some ways for me makes it more horrific
Yes.
in the post-civil rights era
Right.
than the Emmett Till case?
Yeah. So I would actually say that, I mean, I completely agree with you, and I would actually say that in the same way that whites could function as a quasi-police, right, in the pre-civil rights era, that we're having this happen in the post-civil rights era. And so one of the ways this is happening is, right, the expansion of the Castle Doctrine, as Jeannie Sooka said, the expansion of the space in which people are allowed to protect themselves, right? It used to be your home. It used to be you could stand your ground in your home. But now the space has expanded, right? And so then with that expansion of the space has also happened the expansion of the people who, as you point out, don't have an official state role or don't have an official government role. I mean, I think that I absolutely agree with everything you said. I don't know what other to add, but I think that this is, I think they're very similar in that you could say that what's happening today is that in the same way that there was this sort of unofficial extension of police authority to white citizens in the pre-civil rights era, we see the same thing happening in today's society.
Well, you've given us a lot to think about. Let's thank you. Really a tour de force. Thank you all for joining us for it. We hope that you'll join us for a reception in Greenberg Lounge, just across the way. But thank you again for being here, and thanks to tonight's lecture.